Now I'd like to invite Faisal Siddiqui, advocate of the Supreme Court, to give his comments. Faisal Siddiqui is a leading Pakistani constitutional, civil, and human rights lawyer who was one of the founders of two organizations, the Rashid Rizvi Center for Constitution and Human Rights and the Legal Aid Foundation for Victims of Rape and Sexual Assault. He is also an active member of the board of directors of the Pakistan Institute of Labor, Education, and Research. Thank you.
Thank you. Thank you all for coming. Uh, my talk today is a bit different from what Jawad Saab has talked about. I don't specifically talk about the reliance of his academic work in judgment writing. What I would rather like to discuss is the impact of his academic work on the larger canvas of the entire legal canvas. So basically, the impact which it has had, which it should have, rather, in terms of what is called the legal profession, lawyers, judges, other people. Now, the title of my talk is that I've described him as a pioneer of legal scholarship in Pakistan. Now, we have a habit that when people pass away, we, as a cultural habit, either engage in one of the two things. We are either very critical of them, we thrash them completely because they are not around, or we go overboard in terms of our praise of them. So it's important that I justify why I call him as a pioneer of legal scholarship in Pakistan. Now, let me just give you one striking example. If you look at academic legal writings in Pakistan, now, apart from Fazal Karim Saab's books, which books in terms of writing on these macro constitutional issues can you think of? You actually have to go back to 1958 and the fundamental law of Pakistan, A.K. Baroi Saab's book. If you look from 57 to when Fazal Karim Saab wrote these three books, there is actually nothing there. It is really an intellectual desert we have been existing in before Fazal Karim Saab wrote these three books. So in that one sense, in that foundational sense, he is really a pioneer. Now, the other thing is that if you look at Baroi Saab's book, the 58 book, it is not really a relevant book anymore. So much has happened in terms of legal and judicial developments. And really it was focused on the 1956 Constitution. So even in terms of understanding legal and judicial issues in Pakistan, the only academic work really in terms of a book form, in terms of macro constitutional thinking, in terms of macro thinking about the entire legal system, not in terms of a particular subject, his is the only workaround. Okay, so in that sense, he's a pioneer. But then the second question occurs. Is that legal scholarship which he has produced of any worth? Or we simply praise him because we like him? I would try to show that it is both of, it comes at the two levels on which any work of legal scholarship should be judged. It should be judged in terms of excellence and it should be judged in terms of relevance. Any work which is simply excellent and not relevant to the society which exists in is just good English, is beautiful English. And anything which is relevant but really not of an intellectual excellence is good to read but of useless value. Now, it's, in terms of his three main books, it's very difficult in terms of an academic analysis, in terms of legal scholarship, to really have a detailed discussion on these three books. They are just too voluminous, and the breadth of the writing is just too broad. So, I mean, you would need really 3 sessions to even critique the works, if you want to critique it. So that is not what I will talk about when I look at these academic writings. What I want to talk about is what really are the central, what is the central theme in his work? And there are certain central themes. And in terms of those central themes, what is the importance of his work in order to justify that this is a work of legal scholarship which is both in terms of excellence and relevance? Now, as you all know, and people who don't know, the younger students around, is that in terms of his body of scholarly work, he's produced these 3 main books: The Access to Justice in Pakistan, Judicial Review of Public Actions, and Change is the Only Constant. Now, these 3 books are very interesting in terms of their chronological publication. If you look at the first book, The Access to Justice in Pakistan, it is really a book which deals with introducing people to the legal and judicial system in Pakistan. And it deceptively looks like a practitioner's book, but it's not. It's a very conceptual and theoretical book. It doesn't, like any other book, simply talk about that the Criminal Procedure Code has these sections, and under these sections, these case laws have been decided. No. It is a book which talks about the Criminal Procedure Code and the Civil Procedure Code in terms of the fundamental concepts which are envisaged. You would not find another criminal procedure or civil procedure book which starts with first laying down the constitutional framework within which the Criminal Procedure Code and the Civil Procedure Code is to be understood. We actually think that the Criminal Procedure Code and Civil Procedure Code can be understood in itself. FAZAL KARIM dispels that presumption. So his first chapters in Access to Justice are actually about constitutional framework, jurisdiction, interpretation, and then he comes to the Criminal Procedure Code, and he doesn't go to section 1 of the Criminal Procedure Code. His first topic in terms of the Criminal Procedure Code, or the criminal justice system, as he calls this, is on the concept of what does criminal justice mean. So this is really an introduction. So his first book really is about for beginners and practitioners. Then you move on to his second book, The Judicial Review of Public Action. This is very different from the first book. The second book really is a text where he gives you his constitutional thinking within using the concept of judicial review of public action. So you see the jurisprudential and constitutional philosophy, his understanding of the key important concepts when you read this book. This really is a book for scholars and for judges. So it's a very different audience he turns to, and I think that is deliberate. He's left out the beginner's introduction, now he's moved on to more scholarly pursuits. And his third book is very interesting. His third book, which is Change is the Only Constant, is really, he uses the terms that I'm talking about, judicial reforms, but it is really a book about his philosophy of life, his philosophy of history, and his third passion, which is that he really wants to bring about change. So the third book is for reformers. So he begins with beginners and practitioners, moves on to a scholarly text, and then ends up with giving his suggestions about reforms. Now, if you look at legal scholarship in Pakistan, you will basically find 4 kinds of categories of legal scholarship in Pakistan. 95% of books which are produced on law in Pakistan, and the volume is increasing, and even in the vernacular language it is increasing, are really simply statutory or case law compilations. You can't even call them case law analysis. So that is really, I mean, I'm being very generous when I say 95%. I think it is 99%. So, yes, very good for someone who wants to cite it in tomorrow's case, but it doesn't make you think about anything really. It simply makes you recall a case which you might have forgotten or not read. A second category of legal scholarship in Pakistan, which is actually growing, is an analysis of our legal and judicial system from a socio-economic and political perspective. So in the last 5 years, remarkably, you've had 4 judicial histories written about Pakistan. First is Hamid Khan Sahib is here, his book, A History of the Judiciary in Pakistan. The second book is someone who taught here, Muin Chima, quoting constitutionalism, who also looks at judicial review and administrative law. The third is by another professor who teaches, Professor Azim Saab, fascinating book from a Marxist perspective, Law, State and Inequality. And the fourth book recently is Seeking Supremacy. He's a Pakistani scholar at Oxford, Yasir Qureshi. So this is the second category of scholarship which you will find. A third category of scholarship, with the recent publication of the memoirs of Jawad Khwaja Sahab, Slaughtered Without a Knife, you have biography of judges. But Fazal Karim Sahab is very different from the first 3 categories. He is an academic working in the classical liberal tradition. So what you have there in his book is not a concentration of either of these categories. What he concentrates on is to understand the intellectual basis of constitutional as well as legal basis. What is the intellectual logic behind it, rather than looking at external elements like socio-economic and political. So it is the classical liberal tradition which you see abroad of books which are written, textbooks which are written. There were none in Pakistan. That is why his work is so important. Now, I will come back to this issue of a lack of intellectual discourse in the academia on our legal and judicial system. There's been really no literature on that in terms of books, because that's one of the critical points which Fazal Karim Sahab makes in his books, and it was one of his mission, and I'll come to that. Now, his approach to academic writing, his approach to understanding constitutional and legal issues are very different from even a lot of books which you will read abroad. So if you open his book, it is not organized, any of these books, even the first book, it's not organized in terms of a chronology of sections, in terms of purely case law analysis. What he does is that he moves backward and takes a holistic view of the entire constitutional framework, develops a philosophy, develops a theoretical framework, understands while looking at, for example, the Constitution. If you look at volume 1 of the Judicial Review and Public Action, he identifies the main concepts, central concepts in the Constitution. So it's not your typical analysis. So it's a holistic reading, what Baroi Saab called a totalizing constitutional writing in his fundamental laws. The second thing is that before going into text, before going into case law, what you will find in his writing is a conceptualization and a theoretization of the various issues. And then, in order to support that, in order to explain that, you will see a reliance on both Pakistani case law, comparative case law, and various legal literature. And that's the other aspect, this is not a person who simply looks at Pakistani law in terms of Pakistani law. He looks at Pakistani law in terms of one of the elements in this development of the modern constitutional state, the modern legal system, the modern judicial system. So he looks at a particular Pakistani problem, but looks at it in a comparative perspective. One of the other things which is interesting about him, the three elements which actually make his writing both enjoyable and relevant. He has this knack that whenever he is discussing a very dry issue, he will always talk about contemporary debates. That's very important because, frankly, law books are very boring. If clients didn't pay us, we wouldn't really read them. So you have to make law books enjoyable. And the way you make law books enjoyable is that you take up contemporary debates. So in his last book, he talks about the use of judicial dictionaries. And I think he deliberately does that in order to discuss the Nawaz Sharif case. So it's a very interesting, he's always thinking about the audience, how do I make myself enjoyable and relevant? But his books are not mere description. They are critical of contemporary decisions. They are critical of contemporary laws in Pakistan, even critical of constitutional provisions. And then he is creative because he will give his own views about what he thinks is wrong and what he thinks is right. Now, I've given you an overall description, really, of what I think his academic work is about. Let me talk about three contributions which I think his academic work has made. And I'm really looking at the broader picture. I'm not talking about a particular article which he's interpreted, but in terms of his broad framework of his academic writing. I think the first contribution, which is the most important contribution, and I think this was his first mission in terms of writing these books. He has a very interesting quote in one of his books where he says, "For law is the calling of thinkers. The book seeks," meaning his books, "seek to restore the art of thinking to where it belongs, the profession of law." I think this is the central problem why a man who had retired, all his books are written after, in his 60s, remarkable, after his retirement. I mean, these are long books. Judicial Review of Public Action is over 2,000 pages. It's 3 volumes. It's a small text. It's actually 4.5 volumes. It's written in a small text. Laborious work, very difficult work, requires a lot of energy at that age. The reason is that because this was his central mission for writing these books. He thought the central problem in the legal profession is that the art of thinking has disappeared. When I joined the law profession in the beginning after coming back from Cambridge, when I prepared my first case, I remember my senior telling me that, "Faisal, your problem is that you are too much of an artist. You should be an artisan. This is the profession of artisan." That is the central problem, that the art of thinking is looked down upon. Legal problems, constitutional problems are seen to be self-evident. They don't require a lot of thinking. They don't require a lot of reading. They don't require a lot of comparative perspective. This is what Fazal Karim was arguing against. So his first contribution is that if you decide to read his books, and I hope the young people here Do read it. Don't be scared about the volume of this book. That book is not supposed to be read in one go. Even his third book, you can read whatever you like in the book. It is to inspire young people to read. It is to inspire young people to think. It is then to inspire young people to write. And the reason why I think his work will do all these three things is that, I mean, you open the book and you're amazed at how much this man has read in terms of case law, comparative case law, legal literature, in terms of general literature. It's mind-boggling if you go. And, you know, I can look at a footnote and know whether this text was read or it's simply quoted. He's read the text which he's quoted. So that's, I think, his fundamental contribution, his inspiration. And apart from its comprehensiveness, if you read his books, and that's very important, and people who write legal text should be very conscious of that. Don't make it boring, make it enjoyable. Fazal Karim Saab writes in the Socratic tradition. He writes as a dialogue. When you read it, you will realize that he's actually dialoguing with you. He will say, okay, this, no, but there is a counter argument. This, no, there is a counter. So it seems that he's in dialogue with the reader. As I said, he deals with contemporary debates which make it very, very relevant. And you can see that what he's talking about is the contemporary problems which one is surrounded by. Now, his second contribution is that, you know, when you look at, you can argue that why do we need Fazal Karim's book? What's the use? There's so many books on these subjects. There are so many books we can read from abroad. I mean, libraries are filled with it. Why should we bother to read him? Simply because we like him? Or does he bring to the table something which you will not read in other books? I think it does. And this is where I bring his second contribution. No book in Pakistan which does not fulfill the twin criterions of excellence and relevance is of any meaningful, will have any meaningful impact really in Pakistan. It's very important that we have indigenous thinking. That is what indigenous thinking does, is that it brings relevance, things which people don't know abroad. Because the problem with this country is that there is really primary sources. We write on conversations, we write really on an oral tradition. And most of our understanding of the legal system and judicial system is really based on our oral conversations. That is very different from someone doing research abroad. So, relevance. मैं आपको इनके excellence के बारे में एक बात बताऊं. I mean, you read his citations of legal literature and comparative case law, and you will be amazed at his knowledge. But मुझे सबसे interesting बात इनकी comprehensiveness की ये लगी, excellence के हवाले से. ये in his first volume of Judicial Review of Public Action, in his preface, he ends his preface with a verse of Ghalib. And it's not a very famous verse. Salaye aam hai yaran nukta daan ke liye. Now, पहला मिसरा उसका अदाए खास से गालिब हुआ है नुक्ता सला. Only a person who has read Ghalib's Diwan completely would know this verse. The reason is there are 235 ghazals in Ghalib's Diwan. This is the last ghazal and this is the last verse. Someone who's read it, I mean, that was the knowledge of the man on non-legal matters. Of course, he was in love with both Ghalib and Iqbal. His third contribution, and you know, this is what I owe this insight to one of the persons who taught me law, Makhdoom Ali Khan Sahab. A remarkable man, Fazal Karim Sahab. As I said before, a person who reinvented himself after retirement. How many people we know do that? Remarkable. And maybe what he did after retirement is really his lasting contribution in terms of its impact. I mean, वो गालिब का वो शेर याद आता है कि हैं और भी दुनिया में सुखनवर बहुत अच्छे, कहते हैं कि गालिब का है अंदाज़ बयां और. So this desire to be unique, he was always falling in the first verse. बहुत अच्छे, very good judge, very good teacher. But this academic work really, in an intellectual desert like Pakistan, is where his uniqueness comes in. And I think where his lasting contribution will come in. I mean, it's a brilliant example. I mean, लोग, ख़ास तौर पे ये young लोग in their 20s समझते हैं कि बहुत वक्त गुजर गया, 30 साल के हो जाते हैं, बहुत वक्त गुजर गया है. Just imagine this man is in his 60s and he's writing these voluminous books. Just imagine the ambition, the energy, the willpower, the discipline. And this is nothing strange if he was working in a European or American university. I mean, they have a 200, 300, 400, 500 years of tradition of such scholarly work, where you have complete institutional support, both in terms of research assistance, financial resources. This is a work which Fazal Karim really has done on his own. So that's another lesson from his life, which is that forget about what is happening outside your life. Concentrate on your contribution. Concentrate. आजकल बहुत इस किस्म की बातें होती हैं, सब तबाह हो गया, सब ख़त्म हो गया. Fazal Karim looked at it and said, I will concentrate at this moment in my life at what I want to do, what I enjoy doing, what my contribution would be. Self-reliance. Now, last two things. His importance. I've talked about relevance. It's a critical thing. रेलेवेंस के बगैर कोई चीज़, आप कोई बाहर की किताब उठा के ले आए जुडिशल रिव्यू पे और फजल करीम साहब की किताब रखें. Yes, you will find everything which is in that book in Fazal Karim's book, but then after that you will see indigenous thinking about how we should look at our own problems. तो गालिब कहता है ना, इब्ने मरियम हुआ करे कोई, मेरे दुख की दवा करे कोई. Relevance. And that leads to what I think he identified as a central problem in our legal profession. हमारा central problem मेरे ख्याल में फजल करीम साहब के सामने ये नहीं था कि बहुत सारे cases हैं या और कोई problem, even macro problems, civil military imbalance, ये उन्होंने identify नहीं किया. उन्होंने सेंट्रल प्रॉब्लम जो आइडेंटिफाई किया और जिसकी वजह से उन्होंने कहा आई वांट टू इंट्रोड्यूस द आर्ट ऑफ थिंकिंग इनटू द लीगल प्रोफेशन. आई थिंक द सेंट्रल प्रॉब्लम ही आइडेंटिफाइड इज अ मच मोर डीपर प्रॉब्लम. इट इज द प्रॉब्लम ऑफ इंटेलेक्चुअल बैंक्रप्सी ऑफ द लीगल प्रोफेशन. देयर इज नो रिफ्लेक्शन, देयर इज नो इंडिजिनस रिफ्लेक्शन, देयर इज एक्चुअली ए कल्चर ऑफ एंटी इंटेलेक्चुअलिज्म. मुझे याद है मैंने जस्टिस शाहिद करीम साहब जो बहुत एक्सटेंसिवली रिलाई करते हैं अमेरिकन जूरिस, वन ऑफ द रेयर जजेस हु डज दैट इन पाकिस्तान, तो मैंने बहुत ही सीनियर वकील को उनकी जजमेंट भेजी बताने के लिए कि देखिए ये जिस इशू पे हम बात कर रहे थे इसका जवाब उन्होंने दिया. उन्होंने कहा ये बहुत मुश्किल अमेरिकन जजमेंट कोट करते हैं. देयर इज़ दिस कल्चर ऑफ एंटी इंटेलेक्चुअलिज्म कि चीज़ फ़ौरन समझ में आ जानी चाहिए, ऐसी बात होनी चाहिए जो मुश्किल ना हो. एंड दिस इज़ वॉट इज़ लेड टू द क्राइसिस ऑफ क्वालिटी. फजल करीम साहब अपनी किताब में बड़ी कमाल की बात कहते हैं. वो कहते हैं आर प्रॉब्लम इज़ नॉट द लैक ऑफ जजेस दैट द नंबर इज, आर प्रॉब्लम इज़ द लैक ऑफ एफिशिएंट जजेस. उन्होंने कहा हमने इंडिपेंडेंस ऑफ द जुडिशरी तो हासिल कर ली है. नाउ व्हाट वी नीड इज टू कॉन्सेंट्रेट ऑन हैविंग एफिशिएंट गुड जजेस. सो ये जो एफिशिएंसी उन्होंने आइडेंटिफाई की है, इसका ताल्लुक रियली है एक क्राइसिस ऑफ क्वालिटी है जो हम रिकग्नाइज नहीं करना चाहते. दैट इज व्हाई द सेम प्रॉब्लम्स कीप ऑन कमिंग टू द कोर्ट. इट इज ए रिजल्ट ऑफ दिस इंटेलेक्चुअल क्राइसिस. अब आप ज़रा सा सिंपल चीज़ दें, ये फजल करीम साहब ने अपनी किताब में भी डिस्कस की है. अभी तक हम 21st सेंचुरी में ये डिस्कस कर रहे हैं कि कॉन्स्टिट्यूशनल सुप्रीमेसी या पार्लियामेंट्री सुप्रीमेसी. आई मीन हम किस दुनिया में हैं? आई मीन इतने सिंपल इश्यूज हम अभी तक डिस्कस कर रहे हैं. आई थिंक इट्स अ डायरेक्ट रिजल्ट ऑफ कि अभी तक हमने यही नहीं डिसाइड किया कि हमें अपने बच्चों को इंग्लैंड नहीं भेजना चाहिए तालीम के लिए, अमेरिका भेजना चाहिए. और वो बताते हैं अपनी किताब में फजल करीम साहब कि इंग्लैंड इज़ अ डिस्टिंक्टिव लीगल सिस्टम where really it doesn't have certain central elements which America has. Which is, अगर आप अमेरिकन जुडिशियल हिस्ट्री पढ़ेंगे, अमेरिकन जूरिस्प्रूडेंस पढ़ेंगे, उसमें जो 3 मेजर प्रॉब्लम्स हैं जो आपको पूरी जुडिशियल हिस्ट्री में मिलेंगे, वही हमारे मसले हैं. नंबर 1, द प्रॉब्लम ऑफ कॉन्स्टिट्यूशनल सुप्रीमेसी एंड अ वेरी पावरफुल सुप्रीम कोर्ट एंड फेडरल कोर्ट. द सेकेंड प्रॉब्लम, द रिलेशनशिप बिटवीन द सेंट्रल गवर्नमेंट और द फेडरल गवर्नमेंट एंड द स्टेट, जो आपका प्रोविंशियल ऑटोनॉमी का मसला है. एंड द थर्ड इज एन अंडरस्टैंडिंग ऑफ फंडामेंटल राइट्स. इंग्लैंड में तो ये इश्यूज है ही नहीं. इट्स अ यूनिटरी स्टेट. देयर आर नो फंडामेंटल राइट्स. सो दिस इज ऑल ए रिजल्ट ऑफ एन इंटेलेक्चुअल कंफ्यूजन which has arisen because we have stopped engaging in the art of thinking. हम समझते हैं कि ये जो कॉन्स्टिट्यूशनल प्रोविजंस हैं और जो फंडामेंटल राइट्स हैं, ये सेल्फ एविडेंट है. इफ़ यू लुक एट फजल करीम साहब्स बुक, हिज जुडिशियल रिव्यू ऑफ पब्लिक एक्शन वॉल्यूम 2, दैट एंटायर बुक इज ऑन फंडामेंटल राइट्स. एंड ऑन एवरी फंडामेंटल राइट ही इज एक्चुअली रिटन 100 pages on every important fundamental right, trying to understand that. These are very difficult concepts to understand. अभी recent सुप्रीम कोर्ट के केस में घंटों इस बात पे बहस होती रही कि what is the meaning of subject to law. Now this requires a society, a profession to build up its intellectual resources, to develop intellectually. These are difficult intellectual problems to deal with. The second importance of his book, and I'm just going to end here. The last book, बहुत मज़ेदार किताब है. आप पहली 2 किताबें ना पढ़ें बेशक, आखिरी किताब ज़रूर पढ़ें. Because I think it contains his philosophy of life. It's disguised as a book of law. But it's written, really it's written of what he thinks life and history is all about and society is all about. So, bड़ी interesting theory है फजल करीम. If you get rid of the legal jargon, his theory is that people are wrong when they tell you that status quo will continue, that what you see around you will not change. He says no, change is the only constant. Everything will change. Everything will change. Now, it can change for the better, it can change for the worse. That is where his second and third element of his philosophy comes in. His second element is that now, if you want things to change for the good, then start engaging in the art of thinking, reflecting on your problems, reflecting on what the solutions can be. And then when you reflect on them, a desire will develop in you that you want to reform. So these are the 3 pillars on the basis of which he applies and then gives suggestions about what changes should occur in the legal profession, in the constitution, in the various statutes. और बहुत यंग लोगों को बहुत मज़ा आएगा पढ़ के. कोई ज़रूरत नहीं पूरी किताब पढ़ने की. इट्स अ वेरी लॉन्ग बुक. छोटे छोटे इस पे 2 पैराग्राफ्स है, वाई इज द लॉ सो ग्रेट. लीगल प्रोफेशन पे 3-4 टॉपिक्स हैं. Important thing is you will enjoy, even if you don't apply it, you will enjoy it. So read it for the sheer enjoyment. Now, the last thing, a number of critiques can be made of his works, like any work. हमारे जो लेफ्ट के दोस्त होंगे, मार्क्सिस्ट होंगे या जेंडर स्टडीज़ में होंगे, वो कहेंगे this work should be ignored. It's just another example of liberals gone wrong, classical liberals gone wrong. बिल्कुल ठीक, मेरे ख्याल में उसमें कुछ जान है. Yes, one of the great absences in all these texts is, I think, because he belonged to a generation where it did not see an intellectual analysis of our constitutional problems within a socio-economic and political analysis, locating any intellectual debate within the judicial history or the constitutional or political history of that country. These intellectual disputes cannot be seen in a vacuum. Yes, that is a real absence in his work and a genuine critique which can be made of his work. लेकिन फजल करीम साहब इस क्रिटिक से खुश होते, उनको कोई नाराज़गी नहीं होती, क्योंकि जब लोग उनके ऊपर ये क्रिटिक करते और उनकी ज़िंदगी में करते, तो वो कहते, my central mission in life is fulfilled. I have made people to adopt the art of thinking. And he would be happy regardless of whether he accepted the critique or not. So I hope all of you make some steps towards what his central message is to you. Adopt the art of thinking in your life. Thank you.